Hello and many thanks for joining us on the program People, Politics and Power. I am UMUAHIA. Less than 3 weeks after the Electoral Act 2022 came into existence, it has been enmeshed in one form of controversy or the other, just like it was as a bill. The latest is a court ruling which struck down Section 84, subsection 12 of the law. The section provides for political appointees to resign from their positions to be eligible to vote as delegates and be voted for at a party convention or congress. A federal high court in UMUAHIA, the ABIA state capital, presided over by Evelyn Anyadike, last Friday, declared Section 84 sub 12 of the Electoral Act unconstitutional, illegal, invalid, null, void, and cannot stand. The judgment further ordered the Attorney General and Minister of Justice to delete the said Section 84 subsection 12 from the amended Electoral Act 2022. The judge ruled that the provision of the Act ran contrary to and offends the provisions of Section 66 subsection 1F, 107 subsection 1F, 137 subsection 1F, and 182 subsection 1F of the 1999 Constitution as amended. Now, curiously, there is no mention of the plaintiff or applicant in this case, no mention of when the suit was instituted and who the defendants are. Even more curious is the fact that no other parties, including the two houses of the National Assembly that made the law and the Independent National Electoral Commission, INEC, which is to enforce the law, were put on notice or had any representation in court. In fact, the entire legal process was shrouded in secrecy until the judgment was delivered. Unexpectedly, the Attorney General and Minister of Justice, Abubakar Malami, immediately jumped at the judgment, promising to give it effect. This development is coming on the heels of the Senate's overwhelming rejection of a request by President Muhammadu Buhari for the lawmakers to expunge or delete the said Section 84 sub 12 from the amended Electoral Act. Both the Senate and the House of Representatives, which legal luminaries say are necessary parties to this case, say they were not aware of the court case until the judgment. So who done it? Why was the suit filed in UMUAHIA and kept under wraps? Are there any judicial precedents in relation to the issues in question? Who is a public servant and who is a political appointee? Are political appointees public servants? But even more than that is the question: what are the possible implications of this judgment for political parties that are yet to conduct their congresses and conventions? Right? To kickstart our discussion this afternoon, let's take this report from our correspondent in UMUAHIA.
Of the bill, President Muhammadu Buhari had expressed his reservations about Section 84, subsection 12, and later wrote to the National Assembly seeking an amendment. But the move to recommit the bill suffered a setback as the Senate threw it out. Incidentally, a federal high court in UMUAHIA has now done what the president wanted barely 2 weeks after another federal high court in Abuja restrained the National Assembly from tampering with the newly amended Electoral Act 2022. The UMUAHIA court, in a judgment delivered by Justice Evelyn Anyadike, held that the section was unconstitutional, invalid, illegal, null, void, and of no effect whatsoever and ought to be struck down. Justice Anyadike held that Constitution already stipulated that appointees of government seeking to contest elections were only to resign at least 30 days to the date of the election, and that any other law that mandated such appointees to resign or leave office at any time before that was unconstitutional and invalid. Counsel for the plaintiff, Emeka Ozani, while addressing newsmen, stated that by this judgment, the National Assembly is not required to further make any amendments to the section, as the import of the judgment is that Section 84, subsection 12 of the Electoral Act is no longer in existence or part of the Electoral Act.
We had earlier before now, because of the rancor surrounding Section 84, subsection 12 of the Electoral Act, when our client approached the Federal High Court to determine whether Section 84, subsection 12, when read together with sections 66, 107, 137, 182 of the Constitution, is not inconsistent. Now, the court agreed with our submissions, and it has just ordered that Section 84, subsection 12 of the Electoral Act is inconsistent with the rights of Nigerian citizens.
Originally, we honestly believe that it was inadvertence on the part of the National Assembly. It was a big error. And being gentlemen and distinguished senators and the members of the House, I think they will now go back and do the right thing.
The judge thereafter ordered the Attorney General of the Federation to forthwith delete the said subsection 12 of Section 84 from the body of the Electoral Act 2022.
All right, thank you so much for staying with us. Let's get to meet our guests now. Right here in the studio is a distinguished Senator Ajibola Bashiru. He is the spokesperson of the Nigerian Senate and Chairman Senate Committee on Media and Public Affairs. Thank you so much for joining us.
Yeah, thank you. Good afternoon.
Welcome.
Nice being here.
Also joining us virtually via Zoom all the way from the United Kingdom in London is legal practitioner Dr. Kayode Ajulo. Thank you so much, Dr. Ajulo, for joining us.
Well, thank you very much. My pleasure. I'm grateful. Good afternoon.
So, let's begin this way, distinguished Senator. Were you, or indeed the Senate, aware of this suit when it was filed?
We are not aware. When I was inundated with calls from journalists on Friday when the news broke out, I said that we were not served. We were not parties to the suit. We did not have any notice to the suit. But that is not really the issue. And I must say that as a legal practitioner, we must say what it's supposed to be said. The National Assembly need not be joined in the suit where the validity of a law has been put into question. When the law is passed and has been assented to become law, the validity of that law can be tested with the rubricus, the test of the constitutionality by virtue of Section 1, Subsection 3 of the Constitution that says any act or law inconsistent with the provision of the Constitution should be null and void. But be that as it may, I will say that it's unfortunate that the Attorney General of the Federation will go and celebrate a judgment that cannot stand the test of an appeal. And that is why I think perhaps he rushed to issue statements, and as what his lawyer said on television, that the National Assembly apparently did not get it right. With respect, National Assembly position is unassailable in law and in fact. And in fact, it shows that contrary to the allegation that the Attorney General of the Federation levied against the National Assembly when the law was being made, the National Assembly was making law for self-interest. It will appear, and I say it as a Nigerian, as somebody sworn to uphold the Constitution, that it appears that the Attorney General of the Federation is somebody who is actually doing the opposite, doing what is self-seeking. And let me get it right. All the sections referred to in the ruling that I read, referring to unconstitutionality, none of them is opposite to the consideration of Section 84.12. And I will get it to put for Nigerians to properly in perspective. Section 84.12 has two sides. He said when you're a political appointee, you cannot vote at a convention where nomination of candidate will be done. That has nothing to do with qualification. It only shows that when you're an appointee, you cannot vote. It has to do with qualification. So when you are now celebrating that it violates provision on qualification, does that mean that the totality of Section 84(12) was not considered? In law, there's what is called blue pencil rule. Assuming the aspect of qualification without considering even violates the provision of the Constitution, what of the aspect that has to do with that a political appointee cannot vote at a convention? And what is the mischief that the National Assembly was seeking to cure? Is a mischief of not allowing the executive to load delegates at elective convention with appointee that they can appoint under their whims and caprices with a view to skew the electoral and democratic process in favor of a preferred candidate. And I think the logic of that law is unassailable. And there is nothing in the Constitution that says that that would be unconstitutional. So to nullify the entire Section 84(12) on the basis of qualification itself shows that that judgment cannot stand the test of time. Then the other aspect on qualification, all the paragraph Fs that were referred to were talking of person employed in the public service. Cases like Dada and ABIA has established that persons employed in public service have been defined in Section 318 of the Constitution. A political appointee is not a person employed in public service. Particularly, Dada ABIA is a case that I'm very familiar with. It was a case when my predecessor in office, Senator Shola ABIA, was a sitting chairman and contesting to return back as a chairman. A contention was raised that he ought to resign. And the Court of Appeal said no, he's not a person employed in the public service. So a political appointee, and some of us who are elected, we are not persons employed in political political service. Yes. So to now use provisions that expressly talk about persons employed in public service to extend it to political appointee in view of established judicial decisions that had made a bifurcation of what are those employed in the public service and those who are employed is like comparing apple and oranges. And I also shocked when I heard the immediate reaction of the Attorney General and said, yes, we are going to implement. In fact, the most absurd thing, and I hate to say this, I was an Attorney General in my state, that a law can be declared null and void, but no court has jurisdiction to order deletion of a section of the law. So that law cannot be, the provision of the law cannot be deleted. Even when it's declared null and void, it can still be tested in court. And I think that is why the Section 84(12) will continue to be a legal mine. For those that are celebrating that is there, that is no longer there, it is still there. It's still a law until it is tested. Then the question I ask myself is this. Our court has said cases are to be decided on concrete controversy. What was the controversy between the Attorney General of the Federation, who was the defendant, and the chief that claimed to be the defendant? Was he contesting? Does he have a litigable claim against the Attorney General in that contest? Was he contesting an election against the Attorney General? So the question of forum shopping, the question of simulating a hypothetical and academic case for whatever motive, the Attorney General that is the defendant, and celebrating that judgment without even effort at making a thin line between two aspects of Section 84(12). One says you cannot be a voting delegate. The other, the same provision said you cannot be voted for. Assuming the one of being voted for is said to be against the Constitution, what of the one that says they cannot be voting delegate? But it appears, and I say with all sense of responsibility, I am one of those people that believe that Mr. President have not been having good, solid legal advice. And that was why I came publicly, not as a spokesperson of the Senate, but as a citizen of Nigeria, somebody who studied law and a law teacher, to say that even the opinion of the Attorney General was wrong when he came and said there's anything like open grazing in Nigeria. And since now, he has not responded to us. So the rationale for the initial advice given to Mr. President, by which he wrote to the National Assembly, was not sound, and now it's becoming very clear that it's self-serving. And I believe that the judicial conscience of the country, and I've seen a lot of comments by legal professionals are asking questions about the virus and about the genuineness of even that what I may call stimulated litigation.
Okay, Dr. Ajulo, let's begin with some preliminary issues. Before now, there was a court order from a high court here in Abuja, which actually ordered the National Assembly not to tamper with the Electoral Act as amended, the Electoral Act 2022 as amended. And now we have this one from a federal high court in UMUAHIA. Now, what does this tell us about what's going on in the judiciary?
Well, quite very unfortunate, like what I said yesterday. It's quite very unfortunate what we are leading ourselves to, particularly what we seem to be making the judiciary to be. The people's confidence in judiciary is because of what we know judiciary to be, to resolve all issues. And it's expected that judiciary, who we are expecting to resolve issues, should not be one that will compound the issue. It is a known thing that the High Court, Federal High Court in Abuja, has already seized of this matter. The High Court in Abuja has already given an order to the National Assembly on what to do. Now we are having another High Court, a court of competent jurisdiction, making a far-reaching decision and ruling, at least even judgment, on the same issue. Though I know the precedent is that the letter in the ruling should be the one that should take over. But what matters most here is this. Immediately this matter that happened in UMUAHIA, it's so clear that there's element of photoshopping. It's so clear that both the case in Abuja and the one in UMUAHIA, the Office of Attorney General is seized of that matter, and it's expected that the notice, even if in a situation that the court is not seized of the notice of what happened, transpired in Abuja, the parties in that matter who to have informed the court of the existence of another suit. And even despite that, though I know the most distinguished Senator Bashir mentioned that the National Assembly hold not to have been joined. But if the National Assembly hold to not be joined, it holds supposed to be to the peril of the plaintiff, because in a situation where the fruit of that judgment will affect what the National Assembly hold to do. Because I don't really know when it now becomes the function of the Attorney General that will now metamorphose to a printer to now remove and to deduct and to strike out. I don't know where that order from. The order will certainly go to the National Assembly, and all these people who to have been joined. And unfortunately, all deliberately by conspiring between each other, which seemingly looks so, must have done this. And I think what the best thing to be done is, as it is, the judgment of the court, as long as it is in force, remain in force. But since there is this window of appeal, parties, both the National Assembly, now we are talking of proper party, we are talking of interested party, we are talking of statutory party, we are talking of necessary party, even including some NGOs can approach the court as National Assembly, approach the National Assembly, particularly when there is this window of that 3 months to appeal. This is what people should take as opportunity to do the needful. But to now he listened to the office of the Attorney General saying that they are not going to appeal, and seem to even be celebrating such judgment. And like I said yesterday, it's like seeing the Nigerian army celebrating losing battle on the battlefield and saying we will not defend the country again. I think may that day never come when such great office, such exalted office, will be accused of conspiring against the interests of Nigeria. And I think that is what is transpiring. It should not be. We will not even go to the issue whether the plaintiff has locus. Chief Nduka Edede have done a little research about him. His profile did not show that he's interested party. And I believe the court, that's the court with respect, holds, because there are a lot of electoral of appellate decision that even enjoin courts in such cases like this to so moto raise some issue this and this party hold to be here before making such far-reaching. But within 11 days, even I don't think Ben Johnson can break that record. We have a case from the beginning to the end, and to give us play fait accomplished. I think this should not happen. The right thing needs to be done. And if the Attorney General believes he needs to go on with that very soon, this I want to believe, because I believe in instrumentality of the law, this judgment will be reversed.
Okay, stay with us. Distinguished Senator, a lot of people who have spoken up on this matter over the weekend are actually amazed at the speed with which this case was conducted and judgment delivered. And they say, look, this has never happened in many cases in the Nigerian judiciary. So did that come to you as a surprise?
I would say that just like Dr. Ajulo said, there are more than meet the eyes from the circumstance of the case itself. And I will say, the same Attorney General was the one that advised Mr. President, that wrote to the National Assembly that Section 84 as Subsection 12 was unconstitutional, citing plethora of irrelevant and inapposite provisions. It was the same Attorney General that was the defendant in the suit. It was the same Attorney General that immediately the suit was, the announcement was made, already went to the press and said that it will give effect to the provision, even a provision that it should shock any Attorney General that a court could make such pronouncement, to say that somebody should delete a law made by a sovereign body empowered by Section 4 of the Constitution to make law should be deleted. You can say a law is unconstitutional, but that does not give you the power to say it to be deleted. So it's like the precedent that the Attorney General is seeking to put in place is dangerous for our democracy, is dangerous for separation of power, and dangerous for rule of law, if at all. Even if it does not, even if he strongly believes that Section 84(12) is unconstitutional and he abide by that decision, he should have at least appealed that very shocking and rather strange order that a section of the law should not be printed when it has been passed by the National Assembly and assented to by the President. It may well be that maybe the site of that Section 84(12) is haunting or could disturb, or create nightmare for the Attorney General of the Federation.
So in actual fact, the Attorney General was the defendant in this case.
I don't think he appeared more to be a plaintiff than a defendant. The way and manner his lawyer spoke in UMUAHIA and the way and manner his press officer came to celebrate that judgment, I think he just gloating over the fact that the same wrong advice he gave the president is being validated through the case that he did not defend. Because from the statement of his lawyer, which I listened to now, and from the statement that was issued by the Office of the Attorney General, apparently the Nigerian government did not have representation. They did not have any defense in that case.
Now, that takes us to the issue of the principle of fair hearing that Dr. Ajulo talked about now. Now, could it have been just possible for an individual or indeed a group of people to institute a case like this? As far as it concerns the Constitution and it concerns a law made by the sovereign body like the National Assembly, and not have other parties joined in this case.
I'm aware of another suit that is pending at the Federal Court Abuja, aside the one that Dr. Ajulo mentioned. It was filed by somebody who claimed to be either in Namasa or so, and claimed that he wants to contest election. He joined the National Assembly, he joined the Attorney General, and I think he joined INEC in that suit. And I think you see that is a suit that really wants there to be a contest. But just as Dr. Ajulo has said, when you not only forum shop, you also cherry pick your plaintiff and your defender. But I believe that the leadership of the National Assembly, and as well as our civil society organization, will look into that judgment, would, because of the importance it is in deepening our democracy, will be able to say so. And the question about morality, yes, you can say there's a difference between law and morality. The question is Nigerians, and I said should ask our Attorney General, is that we hope that it will not be appealing High Court judgments again, so that any High Court judgment given against the government, he will abide by it. So Nigeria should mark that and begin to watch him, henceforth. Then the questions they should also ask him is that the speed by which he accepted that judgment will be translated to all other pending judgment. And in fact, it will do him well to withdraw all the appellate cases that he has, so that he can abide fully without exploring a right of appeal in favor of the government. Then another question is also this: when you are a sitting office holder and you are conflicted, because it appears clearly that the Attorney General is conflicted in this circumstance, is it not a case whereby you are not in breach of even the code of conduct when your oath to the Constitution and your personal interest and aspiration appear to be conflicted? These are $1 million questions that Nigerians may begin to ask our Attorney General. Is he really serving Mr. President? Is he discharging his duty as the chief law officer of the country? Particularly abhorrent is that thinking that you can just go and print. Even in established legislation, Supreme Court judgment, they call it blue pencil rule. When a law is the blue pencil rule, does not mean you go to government printer to go and regazette, but by rule of inconsistency, you will say this provision have been declared null and void. So strange time, strange people, and political expediency.
Dr. Julo, let's push further that blue pencil rule that the distinguished senator has been talking about. That blue pencil rule seems to apply to judges to delete any provisions of any legislation that is in conflict with the Constitution, and not directing any other person or persons to do so. Now, in this case, the judge not only declared that provision 8412 unconstitutional, but went ahead to direct the Attorney General, not the National Assembly now, but the Attorney General, to delete from a law that has already been made and assented to by the President.
Well, thank you very much. Even as if you knew what I've been reading, the judgment of the court is so clear. As I speak, with me here, I have the judgment of the court, the certified true copy of it. At page 12 of that certified true copy of the judgment. Now, listen, this is what the representative, that the counsel of the Attorney General said. He said he concluded that the court is also duty bound to interpret the Constitution to interpret the Constitution. He urged the Honorable Court to apply the blue pencil rule to strike down Section 8412 of the Electoral Act 2020 and save the remainder of the Act and the labor and the resources put into making it for the benefit of all Nigeria without derogating from their constitutionally guaranteed right, also recognized by the Domesticated African Woman Charter. This is an argument of the counsel representing the Office of Attorney General of the Federation. And this is an argument of the defendants supporting the plaintiff. This one shows that there is a total collusion between the plaintiff and the defendant. And as it is, Attorney General of Federation is someone I hold so much respect for in everything I've been doing. But on this one, it is shown that the Attorney General sees that the other interests apart from the interest of Nigeria has beclouded his office. And I believe the right thing that I believe an honorable man thing to be done, ought to have been done. On the issue of the pencil rule, it's well known. A court of law can give any ruling. But for a court to now direct the Attorney General, particularly when there is a division of power, when there is all the three organs of government, there has a duty that needs to be performed. To now ask the executive to now turn to a legislature to change and to even turn the Attorney General office to a government printer to print and to delete, and I think that is a judgment that is too much. And I think we need not waste our time on this issue. What is wrong is wrong, and that's why, if you notice, I've been so careful to know what to say and not what to say, particularly in public. That the right forum is the needful need to be done by going to the court, because there's no way this such kind of judgment can stand the test of time.
Would you, as a lawyer and an individual, be willing to say file an appeal against this judgment?
No, certainly. Anybody, particularly, mind you, this issue is about issue of Electoral Act and the Constitution. And when it comes to some constitutionality, question on constitutionality, anybody can come before the court once you can confirm and demonstrate your interest, can be before the court as interested party. And I'm sure the court will allow such person to come in to defend and to oppose these shenanigans.
Are you expecting that there could be a plethora of appeals from different quarters on this matter?
Well, no, as it is now, the only appeal will be certainly to the division of the court, that's in UMUAHIA, which I believe will still be in UMUAHIA. And I believe anybody with interest, there's a way for court to consolidate it. But as it is now, it is a case of where someone has murder sleep, and I don't think many people will sleep again.
Distinguished Senator, is there a likelihood that the Senate, as a body, or the National Assembly, as a sovereign, would want to challenge this?
We have not met since Friday. Friday was the last working day last week. We are going to resume tomorrow, and I believe that the Senate, most likely will possibly have an executive session to consider that. So I can't, for now, say that. But I also want to ride on the back of what Dr. Ajula said. The decision in UMUAHIA has been given, but there's also some other pending cases, as I told you, that I'm aware of on the same issues. Yes, the decision that been made is a decision of first instance. It is of persuasive authority, but certainly within the rule of our stare decisis, it is not of binding nature on all other courts. So it may well be that some other judges of the High Court, where there are also pending litigation, may do so. But I read an interesting argument from Dr. Ajulo yesterday in his argument, where he said that the decision may be a landmine for many political appointees in the APC, because it is not yet time to rejoice, because it may well be possible that somebody may be challenged as to participation in an election based on that section 8412, and the appellate court may have a contrary opinion from that of the High Court. And I believe that if the Attorney General really want to help and deepen jurisprudence in Nigeria, it ought to appeal that decision so that we can have a final authoritative position of the Supreme Court of the matter and avoid our electoral system of the kind of unsettled positions, particularly on gender of parties, that riddled our electoral jurisprudence after the 2003 election. So I think this is a matter that will be taken up at different fora, and I believe that if the Attorney General who really want to, is really convinced about the position that the law is what it thinks it is, it should be free to appeal and diligently prosecute the appeal. But a situation whereby a defendant counsel, from what has been read to us, is openly conceding the unconstitutionality of a law assented to by Mr. President, and I think it speaks volume as to the content of our ability to resist the urge to use our office for some other motive apart from what we swore to uphold in the Constitution.
All right, we will push that party line a bit further when we return from this very short break. Stay with us. Thank you so much for staying with us. My guest in the studio is distinguished Senator Ajibola Bashiru, spokesperson of the Nigerian Senate and chairman of the Senate Committee on Media and Public Affairs. And he's joined virtually via Zoom from London by Dr. Kayode Ajulo, a lawyer. Gentlemen, thank you so much for your time. Now, Dr. Ajulo, let's push one other line that you made allusion to, or in fact, you discussed extensively in your statement a day or two ago, which has to do with the implications this ruling will have for political parties, particularly those who are yet to hold their congresses and hold their conventions. Your argument is that it could be a booby trap for some of these political parties. In the meantime, distinguished senator, this position by Julo is that some political parties might just fall into the mistake of obeying this court order and end up having crisis or problems with the candidates or with those they elect at these conventions if they go ahead and disregard the provisions of 8412.
Just as I said, you see, decision is that of the court of first instance. And you have seen that the decision of court of first instance could be tested on appeal and is not binding on another court of first instance. So where a person, for instance, challenge another candidate on the basis of section 8412 and canvass arguments in line with what some of us believe is the authoritative position of the law, and that court agreed with the such a plaintiff, then the person that took the risk of not resigning before contesting, thinking that the decision in the UMUAHIA court is unassailable, does so at his own risk. So, and of course, the decision of either court may be pushed up to the appellate court. But I think on a strong footing, there is a need to know that there is a clear distinction between political appointee, where there is no provision in the Constitution, and person employed in public service. I believe that because of the apparent interest in not defending the suit, the defendant in the case of UMUAHIA did not avail the honorable justice of those relevant authorities where they could have helped the Lord Justice to be able to come to a fair determination of the issue. And I will not join anybody to blame any judge or to castigate any judgment of any court. A case is as good as what had been presented by the parties. And you see, we have adversarial system. You canvass your argument. It's based on argument you canvass. But if a defendant, for instance, had made an admission as to the constitutionality of a law, I think you don't leave the judge with any choice than to so go. So in a real contested case, real life case, contested, decision may be otherwise, and that will put such people who think they can ride on that judgment, which appear from what we have read in that judgment is not really a contested case. The court will not avail of relevant arguments in opposition of the contention of the plaintiff. The court will not avail of existing judgment making distinction between political appointee and public service. The court will not avail of a distinction between the two segments of section 8412, which had earlier enumerated, being a voting delegate and being voted for. They are two different things entirely. And you cannot say that the question of being a voting delegate appear to be matter of constitutionality, for which those relevant sections, those numerous sections cited by the court will be relevant.
But a judge is not expected to on their own do their own research and look at precedents if there are any.
I will tell you, it depends on we run an adversarial system of courts. Of course, the maxim is that law flow from the bosom of the judge. But then, if, for instance, you have a defendant already nudging the court to a particular side, the judge takes the easier option and said, okay, since it appeared that this is not contested. But why I'm shocked is that from what excerpt in the judgment, even the Attorney General representative in the case was talking of blue pencil rule. Then the judge now went overboard to say that
disregarding the
yes, will be done. It's never done before. Yes. It's never done. It's novel. Not only novel, but I think the court lacks jurisdiction to make the order that has been made in that regard. The fact that a law is declared unconstitutional will make that law to be what is called dead letters. It does not mean that it will still be letters on the face of the law. So it's a novel provision that I believe Nigerian jurisprudence will be tested, and then we'll have final authoritative pronouncement of the Supreme Court on the matter.
Okay, let's see if we can reconnect with Dr. Julo now. Yes, he's back with us. Thank you, Dr. Julo. The possible implications of this development for political parties that are yet to conduct their congresses and their conventions. where they will be electing party officials, and in the run-up to the 2023 elections, they will also then be picking candidates for elections. From what you have said in your little brief on it, what do you think the parties should be thinking about right now?
Well, thank you very much. Please, my apologies on that little glitch. I just don't know. Something just yanked me off from the head. But as it is, I did a little research and inventory on the manners and the ways we have in our convention, and particularly when it comes to the leadership. As it is today, except I'll be corrected, only the ruling party, that is APC, is yet to get their leadership issue right, and that's why by the end of this week, they're supposed to have the convention to elect the new leadership of the party. And with this new electoral acts that made it so clear that in event the appointee, that is the political appointee, are allowed to take part either by being a delegate by voting or presenting themselves for election, in any event, their participation shall render whatsoever that is done by such party null and void, which means that there is no leadership. And as it is, only the APC, from my calculation, from my research, and from the information available to me, seem to be fall short of that. And the fear is this: if the APC should quickly, as being proposed by the Attorney General, by trying to set aside the provision of that act in allowing the political appointee to take part in that convention, it's obviously clear that by the time there will be what the position of the Court of Appeal, and again maybe Supreme Court, because this issue is an issue of constitution, because when you are saying that something has already ultravises the position of the constitution, it is a constitutional matter, which we are very sure, particularly a political matter, that will get to Supreme Court. And in the event that Court of Appeal upturn what the High Court of UMUAHIA has done, or maybe the Supreme Court upturn what the High Court of UMUAHIA has done, that one, and you allow now, because we are in haste, there seems to be interest involved, that everyone wants to run to quickly allow the political appointee to take part in that convention. The obvious, what will happen at the end of days will be that all that the ruling party APC has done in that convention will be rendered nugatory. And that means that what happened in Zamfara, what happened in Port Harcourt, that is Rivers State, and every other places where the APC lost their ground, may now be a national disaster to the APC. I'm not saying to all Nigeria. And that is why one needs to raise that warning and to warn them that because of the interest of few others in this party, because of their interest, may ensure that we may not have what we can call APC 2023. That is my fear. I so much believe in APC. I have my interest in APC, and as someone who is an interested party, need to advise APC proper that there is no need to be in haste in quickly using a judgment that is bound to be upturned on appeal. I don't think there's a need for any haste. APC can do without the political appointees, and I think that's what should be. They should follow that word of wisdom and caution.
Distinguished Senator, your party, the APC, will be holding its convention, national convention, in a few days' time, Saturday, 26th of March. If you had the opportunity of advising the party at this point in time as regards this issue, what would you be telling the party?
No, the party, our party is not likely to run. I understand the fears that have been expressed by Dr. Ajulo, but our party is not likely to run into the place. Incidentally, our party constitution is in line with what the Attorney General claimed to be unconstitutional. And I will refer to Article 12.1 of the Constitution of APC, which I have a copy here, if I may read for the public. The national composition. The party organs listed in Article 10 above shall be composed as follows. 12.1, National Convention. Members of the Board of Trustees. national chairman, and all members of the National Executive Committee, serving and past president and vice president of the Federal Republic of Nigeria who are members of the party, serving and past governors and deputy governors of states of the Federal Republic of Nigeria who are members of the party, serving and past members of the National Assembly who are members of the party, serving and past speakers, deputy speakers, and other principal officers of the State House of Assembly, and all serving members of the State House of Assembly who are members of the party, members of the State Working Committee, including that of the Federal Capital Territory, Abuja, of the party, all party chairmen and secretaries of the local government areas or area council of the country, all elected local government council or area council chairmen of the country who are members of the party, 3 elected delegates, at least one of whom must be a woman from each of the local government areas council in Nigeria. As you can see, even from our constitution, political appointees are not recognized to be delegates at our national convention and in any of our elective convention. So that takes me to the point that even in fighting the case at the Federal High Court, it appears that the Office of Attorney General is more preoccupied with the looking at possible qualification for him or some of his acolytes to contest election, without adverting to the fact that even the other aspect of Section 84(12) is even in line with the constitution of our party, to which I believe it belongs to. So as at the March 26th election, there cannot be any legal hiatus that will affect us by strictly complying with Article 12.1, which is in line with the first leg of Section 84(12) that they are saying should be deleted from the from the Gazette.
This is the provision in the party's constitution.
Article 12.1,
which of course, even if 84(12)
is not there, political appointee would not vote at our national convention. The same thing too in the context of emergence of candidates. So you see this litigation that
this also applies to the emergence of candidates.
So yes, the only area where the legal hiatus will come is where a political appointee refused to resign and is allowed by the party to contest. When such is challenged on the basis of Section 84(12), one may not know whether a similar court will agree with decision in UMUAHIA, and then that becomes a legal problem. So we must make a distinction between emergence of leadership at our national convention, which is going to happen by the grace of God on the 26th of March. To that, there's no legal problem, because strict compliance with Article 12.1 will not expose our party to the vicissitudes of litigation based on whether decision in UMUAHIA will stand or any contrary decision will be taken at the appellate court. But when it comes to any candidate, any aspirant, let me use that word, that feels that he has comfort and can rely on the UMUAHIA decision and contest, eventually, if his election is challenged based on Section 84(12), and of course nobody is precluded from making such challenge, and another court took a contrary opinion in that regard, then he may have put both the party and himself in jeopardy in that regard. So I will advise our party to err on the side of caution and not allow political appointee to fly the ticket of our party and contest elections, so that we don't create a problem similar to what happened to our party in Zamfara State.
Mm-hmm. Now, Dr. Julo, your fears are laid now with this explanation given by the distinguished senator.
Don't forget that I happened to be the national secretary of the political party one time, another in my little participation in politics. Sometimes the constitution of the party is not that sacrosanct. The convention has overriding power to even set aside the constitution of the party and allow what the leadership wanted, they can have it. But one thing I think I need to say is that just information coverage means that in my state, that's Ondo State, most of the political appointees, some of them has even resigned this morning so that they can partake in that election. And I believe that is the best way to go. And I'm not worried about that, because when you have the leader of the bar, the senior advocate of Nigeria as the chief executive of the state, I believe the law will be duly followed. And I think I need to commend that the the governor of the state for, I believe he must have an hand in it, so we need to commend it. But as it is, what a law is a law. And what I believe that cannot be subjected to the whims and caprices of the party leaders is that section 84(12), because the other constitution of the party, one way or the other, they can tinker with it and they quickly pass it. But as it is expected, like what the honorable, the distinguished senator Bashir just mentioned some minutes ago. It's always better to err on the side of caution. And I think because of the interest of some few members who are holding political office now, they should not use that to disrupt and to mess up the aspiration of generality of party members. And I believe there must be something we call sacrifice in anything. They need to sacrifice, and we need to let them know one thing. Appointment is not a right, it's a privilege. And once you have that privilege, it's only in Nigeria you see those who are given privilege and now turning to a right and running shroud over everybody. And I think the right thing to be done for the sake of the party and for the future of Nigeria.
Thank you so much, Dr. Kayode Ajulo, a lawyer who joined us virtually via Zoom from London on the program today. Thank you for your time and thank you for your contributions. All right, and here in the studio, we're joined by a distinguished Senator Ajibola Bashiru, who is the Chairman, Senate Committee on Media and Public Affairs and the official spokesperson of the Nigerian Senate. Thank you so much.
Yes, we've enjoyed being here to educate Nigerians on a very interesting topic.
We look forward to having you more often so that you can tell Nigerians what's happening in the Senate. Great. That's our program for today. Please join us again when we bring you a new edition of People, Politics, and Power. Bye for now.